Hi, I'm Phillip Cha. I'm a mediator and founder at Cha Mediation Services. I specialize in mediating employment and business disputes. In this segment, I want to talk about the mediation confidentiality rules in California. What was once a uncontroversial, almost no-brainer of a rule is on the verge of some pretty significant changes. Under the current rules, any communications that are done in the context of a mediation, and that includes anything from discussing who to pick for mediator to the actual numbers discussed during the settlement negotiations, are strictly confidential. The goal and the purpose of these rules is to encourage the parties to be open and candid during the negotiations without fear that anything they say can be brought in and used against them later if the case doesn't settle. Now, the problem with this rule is that it conflicts with the goal of prosecuting attorney malpractice claims based on legal advice given during the mediation process. Now, this issue came into focus in the Cassel case, and for you hardcore law geeks out there, I'll leave a full case site in the description box below. But the Cassel case was about a business dispute where one of the parties agreed to settle the case at a mediation and later sued its attorneys for legal malpractice based on advice given regarding the settlement. Now, the issue for the court was whether there was an exception to the confidentiality rules so that a party could bring in evidence from the mediation process to prove its malpractice case. Now, the court ultimately took a hardline approach and ruled that there was no such exception. At the same time, the court did acknowledge that it was a close call, and it actually invited the legislature to step in and make changes to the rules. Following Cassel, the legislature took its cue and passed a bill proposing changes to the confidentiality rules for this attorney malpractice scenario. Now, due to political reasons, that bill never made it into law. But what the legislature did after it was rejected was commissioned a study to look at these issues and make some recommendations regarding a new proposal revising the confidentiality rules. Since this study began in 2012, the Commission has issued a series of memos and held public hearings regarding proposed revisions to these rules. And what they've done at this stage is propose some new language revising the evidence code to create this exception we've been talking about. And so the current state of this proposed law is that you'd have an exception to the confidentiality rules where the evidence from the mediation is relevant to a claim of legal malpractice based on advice given during the settlement negotiations. Now, the goal here and the idea is to find a middle ground between encouraging the parties to continue to use mediation to resolve cases on one hand, while also protecting parties who may have valid legal malpractice claims. Now, the full name of the study and a link to the website where you can find the memos and other materials I'll leave in the description box. The practical impact of these proposed revisions is that they open the door to more legal malpractice claims. And so what are the types of malpractice claims we may see as a result? Well, for starters, you have your classic case of buyer's remorse, where a party claims that the attorney could have and should have obtained a better deal. You could also have claims involving an attorney's alleged failure to explain the possibility of personal liability if in the case of a breach of a settlement. And so where you may have that come up is where a business entity to a settlement defaults on it, and an individual, like an owner or management, could be left holding the bag. Another potential claim is that the attorney failed to advise the client to seek tax advice. And so where that may come up is if the IRS ever audits a settlement and determines that one of the parties owes additional taxes on the settlement amount. Lastly is an alleged failure to obtain releases as to all related parties. And so where that may come up is where you have a subsequent lawsuit against a related party or entity that should have been included in the original settlement deal. So what are some tips for protecting against these malpractice claims? Well, 4 tips come to mind. One is to document all settlement offers, counteroffers, and settlement authority from your client. To take it a step further, if you're on a contingency fee agreement, you need to walk through, break down, and itemize settlements, including any additional amounts owed for things like attorney's fees, costs, and taxes. Second is to discuss all potential personal liability issues with individuals as well as business owners and management. Third is to advise your client to seek tax counsel as needed. And this is especially true in employment cases where you often have claims that are a mix of wages, emotional distress, and personal injuries. Lastly, you want to make sure you obtain releases for all related or affiliated entities. And so for a company, that it could include insurance companies, consultants, as well as management. Thank you for tuning in. If you like this video, please hit like and subscribe to my YouTube channel. You can also check out my website at www.chamediation.com. I'm also on social media. Links to my Facebook, Twitter, and LinkedIn accounts is in the description box below. And in the meantime, stay tuned for my next video. See you soon.